Welcome, everyone, to this Wedleg Bell podcast. My name is Clive Weber. I'm a partner in the Wedleg Bell pensions team. The title of this podcast is RIP for RPI ? There's plenty of detail on our website, so this podcast is a high-level look at some of the issues concerning possible changes to the RPI. Just a quick overview of the podcast. First of all, I'll briefly consider the history and how we've got to where we are. Then we'll look at the timeline for change, and then the effect of the changes and what the future holds. So turning to the indexes themselves, as I'm sure you'll recall, there's three main indices. Firstly, RPI, established a long time ago in 1956. More recently, CPI, Consumer Prices Index, established in 1997. And then in 2013, CPIH, that's CPI with a housing component. Now, who has power to change these indexes? And how are changes made? The answer to that is that it is procedurally difficult to change the retail prices index or any of the other indexes. Who's in charge? Answer: the United Kingdom Statistics Authority, operating through its executive arm, the Office for National Statistics. What is the governing law? That is the 2007 Statistics and Registration Services Act. Under the 2007 Act, UKSA does not have a free hand in making changes. It must consult the Bank of England, and insofar as there is an impact on certain index-linked gilts, it must first obtain the permission of the Chancellor of Exchequer before it can make changes. So there's a procedural area which is not easy for the government. In terms of present use of the RPI, many pension schemes still use RPI to increase pensions in payment, to revalue deferred pensions, and on the other side of the coin, they often hold gilts, index-linked gilts, the index linking being to the RPI, partly because the government have not been keen to issue CPI-linked gilts. So, as a generalization, everyone holds RPI-linked gilts. So what is the government's proposal? The proposal is that the method and data underlying the CPIH are imported into the RPI. In other words, a watering down of RPI, but RPI will still continue to exist in that watered down form. The impact could be severe. It's reckoned that the RPI produces increases greater by about 1% per year on average than increases under the CPIH. So what is the timeline for making changes? The milestones are referred to in detail on our website, but briefly, we have the change in 2010 when the statutory basis for changing increases to pensions in payment became CPI instead of RPI, but only for those pension schemes which solely use the statutory basis for making increases. Many schemes have a different method and continue to use RPI. In 2013, RPI ceased to be an official national statistic. In 2017, the CPIH was elevated to the preferred measure of price inflation by the Office of National Statistics. And then in 2019, the then Chancellor refused to scrap the publication of the Retail Prices Index as recommended by the Office for National Statistics, and instead decided there should be a consultation to gather views about changes to RPI. That consultation was issued earlier this year. It closed this August, and the government are now considering the position. But there are several wild cards. Firstly, COVID has ravaged the public finances. Secondly, we have a new Chancellor. It was the old Chancellor who undertook to look at the changes to the RPI and decided on a consultation. So in terms of what happens next, if there are to be changes, then implementation is likely to be either in 2030 or in 2025 or at some date in between. 2030 because after that the Chancellor of the Exchequer no longer has any say in what happens to certain index-linked gilts in terms of their index linking. 2025, not earlier than that, because the then Chancellor's view was that it would take all that time to properly put into effect any change to RPI. There is also the possibility of dislocation to the index-linked gilt market and the cost to the government of redemptions of certain index-linked gilt. Equally, there could be savings for the government. Turning next to the impact on pension schemes, the impact could be dramatic. Many schemes holding RPI linked gilts will find the value of those gilts diminished. Whether there's a corresponding reduction in member liabilities would depend on how the scheme is positioned. If the scheme is already CPI linked in its increases, then they will find the index linked RPI gilts they hold diminishing in value, but with no corresponding reduction in member liabilities. The PPF's response to the consultation has been published recently. In their response, the Pension Protection Fund estimate that if the change to RPI goes ahead, the watering down I've referred to, then the cost to the PPF, if the change is made in 2030, could be in the region of £1 billion, and more than that if the change is in 2025. And of course, it is the members who will be hit hardest in a personal sense, because those who've been enjoying RPI increases will in future find those increases whittled down. So what is going to happen going forward? If RPI is changed, then one has the watering down of RPI, and that's likely to be automatic effect in terms of scheme rules. There'll be nothing for trustees to do. They simply have to apply the watered down RPI. That is except in one instance where one sees in scheme rules provisions quite commonly that if there is a material change to an index, then trustees can choose a different index. So the watering down of RPI may trigger such a provision. Those types of rules are definitely something on which legal advice should be taken. If there's no change to RPI, or the change is delayed until, say, 2030, then what are schemes to do? Many schemes have been unable to change from RPI to CPI. Some have managed it, but others have gone to the court to ask for permission, and frequently that permission has been refused because of the actual wording of the scheme rules. An exception to this has been certain cases where it's possible to demonstrate that over time there's been a mistake in the scheme rules. In that type of case, it's possible to go to the court to ask the court to make a correction. That process is called rectification. It's different from the scheme itself trying to make changes. Frequently, schemes cannot do that because there are restrictions in the scheme rules, which means one cannot retrospectively change the basis for members' benefits. So rectification is a possibility. It was demonstrated in the recent case of Univar, on which my colleague Alison Hills will be reporting in our 2-monthly publication, Pensions Compass. And in the recent case of SFS Technologies, rectification was also ordered, admittedly in a different area to do with early retirement, but it was successfully obtained and on a summary judgment, meaning there was no need for a full trial, and therefore that was a relatively inexpensive way of obtaining this result. So one doesn't know what the future is going to hold. By way of summary, we hope this podcast has been of interest to you. The detail is on our website, and please do not hesitate to contact us to draw on our experience of this area, whether you're an employer, trustees, or members. Thank you for watching this podcast.